I'm not sure it's peculiar to California, but when you have employees who are working for a company that files for Chapter 11, you have several issues at stake. One of them is, well, unless you have paid the employees' wages and benefits all the way up to the petition date, there's going to be a pre-petition liability to that employee. Now, employees are not too thrilled about staying with a company that's in bankruptcy if that company owes them a bunch of money, especially if the promise is you're not getting paid a dime on that pre-petition obligation until the plan is confirmed. And in a situation like that, these employees may jump ship. So another first day motion that we prosecute before the court is getting the court permission to pay those employees so that they'll stay on. If an employee doesn't stay on, or the court doesn't really give us that permission, the employee's claim, whether it's for wages or for benefits, is treated very specially in the bankruptcy code. And we bifurcate the wages into those wages that were earned during the 180-day window immediately prior to the day we filed the petition, and those wages that were earned prior to that. Now, you might wonder why an employee would stay on if the wages are in arrears by more than 180 days. Well, sometimes that does happen, depending on the nature of the business. In any event, the wages that the employee earned during that 6-month pre-petition period, up to $15,150, are given special treatment. They are turned into what's called an administrative claim. And what that means is that they get very high priority when it comes to paying creditors in the plan. Now, those wages that were earned prior to the 180-day pre-petition period are just treated as general unsecured debts. And they are kind of bottom of the barrel when it comes to paying claims. The benefits, it's a little bit more complicated. It still looks at that 180-day window and bifurcates things between the 180-day pre-petition period and the period prior to 180 days. What we do is we take the amount paid out in those benefits and divide by the number of employees. And then we subtract out any monies that were paid in maybe some other benefits package, and we get the amount that that employee is entitled to as a benefit for that 180-day window of $15,150. And so, once again, the ideal is if you can have everything square with the employees on the petition date. If it's a big business, that's probably not going to happen. Or if you're concerned that the employees are going to jump ship, be prepared to ask the court for permission to pay them, even though it's a pre-petition obligation.